Hey, good afternoon, everyone. As I said, I was going to come back today and kind of go through some of these notes with you and have this uploaded as soon as possible. So again, we're on chapter 15. I know your notes say chapter 16, but it is chapter 15, the federal courts. And I hope this works. I really hope that you find this helpful for me to kind of go through these notes with you to make sure we're all on the same page. As we look at our judicial system, and we look at letter A here, the judicial system in the United States is an adversarial system. Adversarial, Adversarial. The letter A is an adversarial system. What adversarial means is that our judicial system today, the primary purpose of it is for conflict to be settled. And if you think about the difference between the Wild West and today, where you have a conflict between one another, your neighbor, your employer, what our courts provide is they provide parties that have a dispute to present evidence and to have that dispute settled. So a fancy word for that is adversarial. Our court systems allow today two people, two parties, individuals, businesses, government, whatnot, that have problems that need to be settled in a legal manner. As we move down through the notes here, it's based on the theory that justice will emerge out of a struggle between two contending points of view or two parties. And through this struggle, through this adversarial system, justice will best be served. As we look for number 2 here, what's bolded, in reality, most cases never reach trial because they are settled by legal agreement to reach out of court. Those are called plea bargains. A plea bargain. Plea bargains are used at the federal level. Plea bargains are used at the state level. To be honest with you, plea bargains, and if we were to get to law day this year, plea bargains are very common in both, not only just criminal law, when a plea bargain truly is someone who's going to plead guilty to a lesser charge. But what it alleviates our court systems from being overworked. Its primary purpose is to prevent going to trial. Trials are expensive. Trials are time consuming. Our courts are already overworked. So a lot of times today, prosecutors at the federal and state level will look for ways for individuals where it's kind of a clear-cut case, where they might plead to a lesser charge. They're going to do less time or have less of a punishment in order to alleviate actually going to trial. So that is called a plea bargain, and plea bargains are very common today in criminal law and also mediation. When you go talk about civil law in a second here, we're going to civil law. To prevent an actual trial in civil law, those two parties that all of a sudden now they don't have, there's been no law broken, but they do have some kind of contention between one another. Oftentimes courts will try and use mediators to reach out an agreement. If for whatever reason I'm involved with a lawsuit against somebody else and I'm seeking damages, prior to us going to trial, there could be a mediator that would meet with us to determine if we can come up with some kind of agreement or settlement before we go to trial. So our court systems at the federal and state level both use a type of plea bargain that would be more criminal law, or more mediation that would be more civil law. But getting into the two types of law now for number 3, letter A, criminal law. Criminal law is a punishment for someone who commits a crime. Criminal law is an individual who is charged with breaking a law. It's a statute. It's a law. Whether it's the Ohio Revised Code at the state level or whether it's a federal law. And criminal law, both at the state and federal law and federal level, they differ. So when you guys think of most crimes today that are committed by individuals across the area, most of those crimes are Ohio Revised Code, they're state statutes. So for instance, I know the first thing that comes to your mind is often murder. That is a criminal law. There's a punishment, but that is part of Ohio Revised Code. At the federal level, there are federal laws that do exist. If you commit a federal crime, then obviously that's part of criminal law. Whenever you think of criminal law, you're thinking of individuals who have broken some kind of law, whether that law is speeding, or whether that law is robbery, whether that law is arson, whether that law is cheating on your taxes, whatever that situation might be between the federal and state level. I'll give you an example of a federal crime. If you commit a crime across state lines that becomes a criminal law, that'd be something the federal government would handle. Tax evasion is going to go to the federal government. Violating the Clean Air Act would go to the federal government. We do have federal courts in the state of Ohio. I'll get to that a little bit later in today's lesson. Civil law is now a non-violent, non-criminal dispute between two parties. And when you think of civil law, you need to think of lawsuits. That an individual is suing another individual, an individual is suing a business, an individual is suing the state, an individual is suing the federal government, a business is suing the state, a business is suing the federal government. They are non-criminal. There's been no federal law violated, no Ohio Revised Code violated. Simply, we have a dispute that needs to be settled. And when you think of civil law, think of lawsuits. I know that most of you have heard of the lady who spilled the McDonald's coffee on her lap, and she was awarded a settlement of a couple $1 million in a lawsuit. That's what you need to think of. In all honesty, most civil law is going to deal with disillusions, child support, child custody. I hired someone to perform some work on my house. I paid them up front. They didn't complete the work, and now I want to get my money back. I have a lawsuit. So when you think of criminal law, you've committed a crime. An individual has violated, whether it's federal law or state law. When you think of civil law, we have a lawsuit. My neighbor cut down a bunch of trees. He thought they were on his property. They were on my property. We have a dispute that needs to be settled. In civil law, individuals usually seek damages, and damages are often financial. All right. So civil law versus criminal law. Criminal law, there's an actual law that's been broken. Civil law, and as we move forward with the abundance of court cases that we're going to talk about, civil law is a student, like in Tinker versus Des Moines. 3 students got suspended from school. They felt their constitutional rights were violated, so they sued the school. All right, so that's the concept of civil law. As letter C, the vast majority of cases do involve state law and are tried in state courts. All right, as we look at participants in our judicial system, we have federal judges. And again, I'll keep referencing the state level because you guys know Judge Tamakis, you know Judge O'Farrell, you know Judge Kate. And I know we're going to focus specifically on the federal level here, but federal judges, they are the #1 participant. As you guys know, federal judges get to serve for life. And federal judges today, whether they're district court judges or appellate court justices or Supreme Court justices, they are restricted to the types of cases that they decide. And if you look at #2, today courts can only decide what is called a justiciable dispute. Justiciable is spelled Justiceable. A justiciable dispute. Justiciable means that the conflict can be settled by a legal method. So when you're thinking of what is and what is not justiciable, you're thinking, can this conflict be settled in a court system, or does our court system have the means to settle this particular conflict? So what is justiciable is what can be decided or what can be determined by a court using our legal methods. Now, as we look at those involved, obviously we have federal judges. Outside of that, the other parties that are going to be involved in this process are going to be what's called the litigants. So the plaintiff and the defendant. The plaintiff is the person who brings the charge. And if it's criminal law, the plaintiff will be the federal government, be prosecutors for the federal government. If it's, and at the state level, would be prosecutors representing the state of Ohio. If it's civil law, the plaintiff will be the person who is seeking damages. It's the person who has had some kind of financial or emotional hardship, and they are suing somebody else. The defendant is the person whom the charge is brought against. The person whom the charge is brought against. And the defendant in criminal law is the individual who is being charged with a crime. They are the person who committed the robbery. They're the person who committed fraud. They're the person who is dealing drugs. In a civil law, the defendant will be the person who caused hardship on the other individual. All right. Together, number 4, the plaintiff and defendant together, they are known as litigants. Litigants. And today, if you are seeking a lawsuit against somebody else, you have to have what's called a standing to sue, and that's the other fill-in. So the plaintiff and defendant, known as litigants for number 4, they must have standing, or they must have standing to sue, which means they must have experienced some kind of financial or physical or emotional hardship because of somebody else. If there is no standing, then the court, it is not justiciable, and the court will not decide that case. So standing to sue, and when you're thinking about standing, does this individual who's in this case, and at this time would be the plaintiff, have they demonstrated there's a serious interest? Have they demonstrated actual physical harm, emotional harm, financial harm because of another individual? And if there is no standing, then that is not a justiciable case. Again, Thursday, we can take questions over these. If you guys have any more questions, you want me to clear this up, we can do that on Thursday. Class action lawsuits, we actually covered in interest groups. And so as we go back through interest groups, because we talked about interest groups using them, but they obviously don't have to be made by interest groups. Individuals who have, what a class action lawsuit is, they're people who are similarly situated, who form a single lawsuit, and they are going to share in the reward. If there are damages that are sought, they're going to share in the reward. So really, it's a group that's going to collectively form a single lawsuit. They're going to join a lawsuit. There's going to be someone who represents a larger group as they're working their way through the courts. This is a class action lawsuits are an example of civil law. It's an example of individuals who are similarly situated, who all have the same situation. They've all had the same hardship. Okay, and whether that is coming from a business or from government, whatever it might be, they're just going to combine their grievances, or they're going to join an individual who already has a lawsuit formed, and they're just going to share in the reward. So we talked about class action lawsuits earlier in the year, and I talked to you about female employees of Walmart formed a class action lawsuit against the company for discrimination. We talked about EPA, environmental lawsuits. There's a lot of environmental lawsuits where individuals who are similarly situated form a lawsuit. They're going to go after a business. If they win that lawsuit, then they're going to share in the rewards. So we had talked about those with interest groups, but I wanted to bring that up one more time, class action lawsuits. If you guys are watching TV, and I'm sure you're watching a lot of TV, have you ever experienced mesothelioma, right? Call the guy at Elk and Elk, and he'll take care of you. Those are class action lawsuits. All right, the structure of our federal judicial system. So that's just kind of some background. Now we're going to get into more of how our federal government and our federal judicial branch is created, is structured. This is going to be a little bit challenging here for me to kind of explain through these notes, and I'm going to try my best. And this might be an area where you guys do have some questions down the road for Thursday. But as we look, excuse me, as we look at number 1, up here, we know that the Constitution tells us one thing. The Constitution in Article 3 tells us we are going to have a Supreme Court of the United States. And then the Constitution tells us it is going to be Congress's responsibility to create, establish, and set the parameters of all other courts below the Supreme Court of the United States. And in 1789, and this is your answer for number 1, in 1789, Congress passed what was called the Judiciary Act. Now, you are familiar with the Judiciary Act because the Judiciary Act of 1789 was challenged and ruled to be partially unconstitutional in the case of Marbury versus Madison. But what the Judiciary Act of 1789 is going to do, it's going to lay the framework for our constitutional courts. Our constitutional courts are the courts that you are familiar with. They are the district courts, our courts of appeals, better known as our circuit courts, and the Supreme Court. And that's what we're going to spend most of our time talking about throughout this chapter, is the constitutional courts. Our constitutional courts are also called our Article 3 courts because they derive their power not from Congress, but they derive their power from Article 3 of the Constitution. So when we look at our constitutional courts, at the highest, there's a three-tier system. At the highest is the Supreme Court of the United States. Below the Supreme Court, now these were created by Congress, but they fall under the constitutional court structure. We have federal courts of appeals, and today we have 13 total federal courts of appeals. We have 12 courts of appeals that span across the country, and then we have one special one that's going to sit in Washington, D.C. that I'll get into in a little bit. We also have 94 federal district courts across the country. So, recapping on number one, the Judiciary Act of 1789 created our system of constitutional courts called our Article 3 courts. We have three types of constitutional courts. They work in conjunction with one another. At the highest level, we have the Supreme Court. Below the Supreme Court, we have our federal courts of appeals, right, better known as our circuit courts. And below those courts, we have our federal district courts, right? All of those are lumped together into what are our constitutional courts, and that's what you should think of. When someone commits a federal crime, or someone is using a federal court in terms of civil law, it's going to be in one of these constitutional courts. And as we move through this chapter, and as we start working on court cases here over the next couple of weeks, all of those court cases are going to take place. They're going to start in a district court. They're going to go through a federal court of appeal, and then they're going to go to the Supreme Court of the United States. Now, looking at number two, Congress has also created what are called legislative courts. Legislative courts. These are special courts. They're known as Article 1 courts. They are special courts that specifically work on congressional power. So we know that Congress has enumerated power. One, power to tax. So we have special courts that deal with taxes. These would be our military courts that exist. Well, we know Congress has the power to make laws over our armed forces. So our Article 1 courts are going to deal with very specific purposes based on Congress's constitutional enumerated powers. Their judges do not serve for life. And those courts don't carry the same civil liberty, constitutional protections as other courts. I don't know if you guys are familiar with military courts, but you do waive some constitutional authority if you are in a military court. So we're going to spend all of our time on these constitutional courts, our Article 3 courts. Judges serve for life. There's three tiers, but I do want to make you aware that Congress also has legislative courts. They're very special courts. Their judges don't serve for life. They serve for fixed terms. And you as an individual lack certain constitutional protections in those courts. Okay, let's move down here, and we're going to talk only about our constitutional courts now, this three-tiered system. And we're going to start with what are called district courts. District courts are courts of original jurisdiction. District courts are courts of original jurisdiction. They are trial courts. They're the only courts in the federal government where trials are held and juries are impaneled. District courts are like our Court of Common Pleas at the local level, at the state level. If someone commits a crime, they're arrested, they're indicted, the grand jury obviously finds that there's enough evidence to go to trial, so they're indicted. There's a trial date set. All of the hearings take place. They go through a trial. They're found guilty. It's really the first level. It's step one. In our federal district courts, they are courts of original jurisdiction, and they are our trial courts at the federal level. So if an individual is charged with a crime in criminal law, if an individual is charged with a crime in criminal law, violating a federal statute, they are going to go to a district court. Every state has at least one district court. In the state of Ohio, we have two. The state of Ohio is split into half, the north and south, and we have multiple federal courts across the state of Ohio, where the jurisdiction from Columbus up would fall into a federal court, either in Akron or Cleveland. Parts of Columbus and down would go down to Cincinnati area. but every state has at least one federal court. We have jurisdiction over 2 federal courts in the state of Ohio. Ohio split into 2. But these are trial courts, and they operate much similar to a local level where juries are going to be impaneled, and the prosecution is going to present evidence, and the defense is going to present evidence, and then a jury has to decide. I do want to make note that during these district courts, they also are the very first court. So anytime, when you think about district courts, it's the first time something's being heard. First court to hear a case, first court to try a case, or only court to try a case. But they will also try civil law. And civil law can take place if I'm suing a business outside of the state. I'm suing something that is between myself in Ohio and a business in California. This can also be the original jurisdiction if I have a lawsuit. Maybe I'm suing Union Hospital, but my lawsuit exceeds a certain amount of money. Maybe my lawsuit is, I'm seeking in damages $1 million. Because of the excessive amount of the lawsuit, that lawsuit could go directly to a federal court. All right, so district courts, courts of original jurisdiction, they are trial courts. They hear both criminal and civil law. Every state has at least one district court. And today, just to give you guys a number for 2A, 98% of all criminal cases are actually heard in state court, not federal courts. So keep that in the back of your mind as we move through this process. 98% of all criminal cases are heard in state and local courts, not in federal courts. Today, we have a total, for number 3, we have a total of 670 district court judges. A total of 670 district court judges. They preside over the case alone. And jurisdiction, you guys can see, what would send you to a district court? Well, what's going to send you to a district court is you violate a federal law. If you violate a federal law, you're going to go to a federal district court. You can see bankruptcy proceedings. We're going to send you to a federal court. You can see any kind of civil lawsuit that would file under federal law. Any kind of civil lawsuit that is excessive in the amount of money. Naturalization of individuals. You become a U.S. citizen in this country through naturalization. A federal judge has to officially naturalize you. Those are all things that are going to go to a federal court. Now, the next level we have is our Court of Appeals. These are called, number 1, U.S. Courts of Appeals have appellate jurisdiction, my fault. They have appellate jurisdiction. Appellate jurisdiction meaning they are hearing the case upon review. So we have these courts of appeals. They are called circuit courts. There are circuit courts. Their job is to review the decision of the district court to determine if the previous court got it correct, to determine if an individual's constitutional rights were violated in the previous court's decision. And when you think about the courts of appeals or our circuit courts, think about it this way. If you guys go and you ask mom and you want to go do something, and you go ask mom and mom tells you no, right? What's the next step? Well, the next step is you go ask dad, right? And hoping that dad tells you yes. And that's kind of the concept with courts of appeals. The federal government does not have the ability, if they are the prosecutor, to appeal their decision. So this is going to be done at a criminal level. This will be done just by defendants. All right. Now, if it's civil level, either can appeal their decision. But put yourself in the position where you are a defendant, you are found guilty by a federal district court, you are sentenced to some kind of punishment, right? Whether it's jail time or prison time in a federal prison or whatever the situation might be. If you feel like that court got it wrong or your constitutional rights were violated, you can file an appeal with one of our 12 courts of appeals. That brings me to the next point. We have 12 courts of appeals, right, across this country. And if you scroll down to the bottom of these notes, and this might take a little bit of time here, there's 17 pages. Okay, so you guys can see here that we have, these are our trial courts, our U.S. district courts, all right? We have 94 of them. We talked about that already. And then we have these appellate courts. We have 12 circuit courts, and we have one very special one I'll get to a second. And then we have our U.S. Supreme Court, our SCOTUS. And then here we have other federal courts, veterans appeals, tax courts, military courts. Those are what we called our legislative courts. Okay, but what I want to get to here with you is this right here. So here's our courts of appeals. We have 12 of them plus a very special one that is going to exist in Washington, D.C. Like I said, I'll get to that in 1 second. We are part of the Sixth Circuit. So if you guys are looking at number 6, there is a court of appeals in the Sixth Circuit that is going to deal with all federal appeals, all appeals from federal courts from Michigan, Ohio, Kentucky, and Tennessee. So if a federal case happens in Tennessee, the district court, an individual wants to appeal the decision, it will go to the Sixth Circuit Court of Appeals. We have 12 circuit courts across the country today. Okay, so not only do our courts of appeals handle all appeals from the federal, at the federal level, okay, but as you guys can see here, they also are going to deal with any issues that come up with regulations from our federal agencies. And so this answers about 70%. About 70% of what the federal courts of appeals, our circuit courts do, that work comes from district courts. The other work of what they're going to do is going to be enforcing orders or challenging orders of our regulatory agencies. That is another task that our courts of appeals have. Each court of appeals, for letter B, each court of appeals will hear cases and panel consisting of 3 judges. And again, there's no trial. The trial has already been held. And so if you have an individual who's filed an appeal, they will present the briefs. Both sides will present the briefs. The judges will hear oral arguments. There's going to be 3 judges that sit on that case, and then a majority vote will decide. They're going to decide a couple things. They're going to decide, number 1, that the previous court got it correct. Or they're going to decide, number 2, that the previous court did not get it correct, and they're going to overrule or they're going to change the court's ruling, the previous court's ruling. But it has to be done by a majority vote. Now, number 3, you guys know that there's those legislative courts that we talked about. When I told you that we have kind of 13 circuit courts, or 12 plus 1, or a special one, this is that special one. And the special court is called the Court of Appeals for the Federal Circuit. So number 3, the Court of Appeals for the Federal Circuit. The Court of Appeals for the Federal Circuit. And it is a court of appeals, but the unique part to this one, it is housed out of DC, and the unique part to this circuit court is that it only hears appeals from our legislative courts. It will only hear appeals from our Article 1 courts, a very special court that Congress creates. And that takes us to the last court, and that is the Supreme Court, the court of last resort, highest court in the land. The U.S. Supreme Court is the only court that is established under Article 3 of the Constitution. As you know, there are 9 justices that sit on the bench. There are 8 associate justices and 1 chief justice. That size of 9 is not set in stone. It's not set in Constitution. That size of 9 has been changed and tried to change. You guys know FDR tried to change it. And as we look at the Supreme Court of the United States, important functions as the court of last resort, as the highest court in the land, is to resolve conflicts amongst the state, maintain national supremacy in law, make sure that law is uniform across the country and how it's interpreted and how it's applied. All justices sit together, they make decisions together. The Supreme Court is unique. If you go up here, it controls its own agenda. It gets to set its own docket. See, the Supreme Court, as we talk about jurisdiction, by the way, is the authority to hear a case. What jurisdiction is, the authority to hear a case. And the Supreme Court is unique because it's the only court in the federal government that has both original jurisdiction and appellate jurisdiction. There are very few instances where the Supreme Court of the United States can be the very first court to hear a case. Very, very few instances where the Supreme Court of the United States can be the very first court to hear a case. But 99% of what the Supreme Court does is based on appellate jurisdiction. They are granting review to a case that's already been decided. The Supreme Court can hear cases from both federal and state courts. However, it's very rare that they hear cases from state courts. The vast majority of decisions that the Supreme Court makes is they are making decisions based upon federal courts and cases that have arisen or went through our federal court system. All right. But they can hear cases from state courts if it has a serious federal issue or federal question. Don't forget, the Supreme Court does not settle matters of state law. They don't determine guilt or innocence. The Supreme Court determines constitutionality. Was this individual's constitutional rights violated? Yes or no? As we look at the Supreme Court letter A, although the president gets to nominate and fill judicial posts, as you guys are well aware, the Senate has to confirm. That's going to be a majority vote. Letter B, federal judges are constitutionally guaranteed the right to serve for life. B, number 1, judges can be removed by impeachment, and it's only occurred 8 total times over 2 centuries. Pretty remarkable. No Chief Justice or no Supreme Court justice has ever been removed by office. Now, looking at number 1, the lower courts, judicial selection procedures. The customary manner in which the Senate disposes of state-level federal judicial nominations is through what is called senatorial courtesy. It's known as senatorial courtesy. It is a tradition, much like the seniority system we talked about with Congress. It is a tradition, and here's how it works. When there's an opening for a federal district court judgeship, the president, before making the official nomination, will check with the senators of their party, 1 or 2, both, will check with the senators of their party where that judge is going to serve. Remember what I told you, all federal district court, all states have at least 1 federal district court. And if there's an opening for a judgeship, and this is known as senatorial courtesy, the President of the United States will reach out to a senator or both senators of the president's party where that nominee is going to serve. If any one of the senators of the president's party has an objection, the president will typically pull that nomination. All right, it is a powerful practice. It's been used for a very, very long time. When it comes to our circuit courts, the president will check with senators, relevant senators, not from where the judge is going to serve, but where they currently live, what state they currently are residing in. As you guys know, our circuit courts encompass multiple states. As we look at letter D here, when there's a vacancy for a district judgeship, 1 or 2 senators of the president's party from the state where the judge will serve will suggest 1 or more names to the attorney general as well as the president of the United States. The Department of Justice and the FBI conduct competency and background checks on these people. The president usually checks the nominee from those who will survive the screening process. As we look at the Supreme Court, when the Chief Justice position is vacant, presidents usually nominate someone from outside the court. They typically don't, I guess, promote somebody from within inside. But as we look at the Supreme Court here, 3A, the president usually relies on the Attorney General as well as the Department of Justice to identify and screen candidates for the Supreme Court. Senators play far less of a role in the recruitment process for the Supreme Court as they do typically for our federal district and circuit courts. As we look at failure to confirm, presidents have failed 20% of the time. 20% of the time to get Senate confirmation. That number is by far the highest number across government of all of the positions the president gets to nominate. We know that in the Senate, for number 2 here, the Senate uses its Judiciary Committee, and the Judiciary Committee has the responsibility of screening that candidate's background. There's going to be open hearings. There's going to be tough questions. It's a very, very hard process to get through. I think that we kind of remember Justice Kavanaugh and his screening process. I know Sonia Sotomayor, her process, her Judiciary Committee hearing was 2 days long, 8 hours apiece. It's a very, very difficult, I guess, job interview. And the senators serving on that Judiciary Committee, they all have a background in law. They all understand judicial philosophy. They have all kinds of questions about standing precedent, like Roe v. Wade, and amongst other things. And as we look here, presidents, their nominations are most likely to come into trouble, as you guys can imagine, when there's divided government, when the president's party is in the minority of the Senate. And that's why it is so important, presidents of the United States, if they have the same party as the United States Senate and can push through judicial nominations, is very important. As we look at backgrounds of judges and justices, our district circuit court judges, judges obviously aren't a real accurate cross sample of the American population. They're lawyers, overwhelmingly white males. They've typically held office as a judge or prosecutor prior. As we look at the Supreme Court justices, they have served on lower federal courts. They were district court judges. They were circuit court judges. They are a very elite group. As we look here, all have been lawyers. All but 6 have been white men. And as we go through this, Thurgood Marshall was the first African-American justice. That is important. We do want to remember that was nominated. Sandra Day O'Connor is the first female Supreme Court justice. We know that Clarence Thomas is still on the bench. Ruth Ginsburg is still on the bench. And then we have Sonia Sotomayor, was the first Hispanic American to be a justice. And so we've only, throughout the history of the country, we've only had 6 non-white men serve as justices on the Supreme Court. All have had great experience as a judge, most often at the circuit court level. When making the selection, as you guys can imagine, partisanship is very important, right? This is a prestigious plum. Talk about the Plum book, last chapter, right? And as we look at when the president determines who's going to serve in these positions and who's the president going to nominate, was this person a party member? Do they support our party? What is their ideology? And the hardest part for us is, to think about individuals in this country. They all have political beliefs. We all view the Constitution and the role of government differently. Judges are not insulated from that. And so justices view the role of government differently. And we'll talk about this later in the chapter. Justices view the role of government differently. Justices view the Constitution differently. And so the president wants to make sure that they are nominating individuals for federal judgeships that can serve for life that share the same political party beliefs, ideological beliefs, and will continue the president's policies down the road. Very important. Okay, deciding which cases to accept is the first step in policymaking. Courts of original jurisdiction cannot easily decide what cases they're going to hear, right? Because if someone commits a federal crime, then they're going to go to federal court. The Supreme Court's different because the Supreme Court of the United States, 99% of what the Supreme Court does is appellate jurisdiction based. And the Supreme Court is unique. The Supreme Court gets to set its own docket. A docket is just an agenda. It's a schedule. It's a list of court cases waiting to be heard. Number 3, there are approximately 8,000 cases. 8,000 cases that are submitted to the Supreme Court every year. 8,000 cases that are submitted to the Supreme Court every year. 8,000 requests where people across this country have lost. They lost at the circuit court level. They lost at the state level. And they are reaching out to the Supreme Court saying, please, will you hear my case? Right? So there's 8,000 cases submitted every year to the Supreme Court. Here's the number that I want you to know. The Supreme Court will only make decisions on about 80 cases a year. 80 to 100, but typically around 80 cases a year. The Supreme Court gets 8,000 requests, but will only choose 80 of those cases to make decisions on. Now, we're focusing only on the Supreme Court here. And looking at functions of weekly conferences, step 1, establish an agenda. Conference is when our 9 justices meet together. It is secret. It's one of the few aspects of American government that I still really enjoy, that our Supreme Court has discussed and heard and made decisions on cases that we still don't know how they decided. They meet in what's called conference. So the 9 justices meet in conference at least once a week. It operates under the strictest secrecy. There's 2 things that take place in conference. Number 1, the justices decide what cases they're going to hear. Number 2, they make decisions on the cases that they have heard. So looking at letter C, the justices consider what's called the discussion list. And I'll get to that in a second here. Most of the justices rely heavily on their law clerks, LAW, law clerks to help screen cases. So if there's 8,000 cases that are appealed to the United States Supreme Court, and the Supreme Court's going to decide 80 on them, there's going to be a screening process. Each of our 9 justices have individuals that work for them. They're called law clerks. Justice Kavanaugh worked for Justice Scalia as a law clerk way back in the day. And one of the jobs of the law clerks is to help screen cases. And they're going to, what the law clerks are going to do, they're going to choose a couple cases that are going to be on the weekly discussion list. And so in conference with the 9 justices and only those 9 justices, once a week, they will decide what cases they're going to hear. If you go down to letter E, if 4 justices agree to grant a review of a case called the Rule of 4, it will then be scheduled for oral argument or decided already within conference. And I'll get to those 2 things at a later date. But letter E, if 4 justices agree to grant a review of the case, it's known as the Rule of 4. It takes 4 justices in conference to agree that they want to hear this case, that they want to make a decision on this case. Once that is decided, once 4 justices, and obviously it's 4 today because they need them. It's a protection for the minority justices to have their voice heard. So, but that's called the Rule of 4. Now, letter F, I cannot stress this enough. I tell you guys to underline, highlight, circle, star it. This question, I know it's going to be a little different this year, but this question is a really common question. It's super, super important. And the most common way for the court to put a case on its docket is by issuing a writ, W-R-I-T, of certiorari. A writ of certiorari. A writ of certiorari. Certiorari spelled C-E-R-T-I-O-R-A-R-I. A writ of certiorari. What a writ of certiorari is, it's the formal approval that the Supreme Court is going to hear, they're going to try and decide, or just they're going to decide, hear a case. A writ of certiorari is an instruction to the lower court, the court that previously decided this case, the formal document that will order the lower court to send up everything they have for review. So the most common way that the Supreme Court says we're going to put a case on our docket, we're going to hear this case, is by issuing a writ of certiorari. A writ of certiorari. All right, it's just instructing the lower court to, hey, look, we're going to hear this case, send us all the briefs, all the information, all the evidence, everything that you guys have, send it up to us for review. Letter G, the blank has an important influence on our federal court. This position is called the Solicitor General. The Solicitor General is a presidential appointee. They're the 3rd ranking official in the Department of Justice. The Solicitor General is in charge of appellate court litigation of the federal government. Now, the Solicitor General has one job. The Solicitor General in the Department of Justice represents the United States government anytime the United States government is a litigant in front of the Supreme Court. So the Solicitor General is the individual that will be providing oral arguments, putting the final touches on any briefs that are submitted anytime the U.S. federal government is formally involved in a court case. The Solicitor General also gets to determine what cases are going to be appealed to the United States Supreme Court. So that's a very important job within the Department of Justice. Okay, making decisions. The second task of weekly conference is to discuss cases that have been accepted and argued before the court. This right here, The court will meet from the first Monday in October until June. That's when the court is in session. They will recess for the summer and early fall. Believe it or not, kind of like how school operates, the court will recess. They will go and they will read and they will write and spend time away. But from October to June is when the court works. They will hear oral arguments in 2-week cycles. So they're going to go 2 weeks of oral arguments, then 2 weeks off, just in conference. And a lot of students try and ask the question at this time, why is that? And I can't stress to you guys enough, this is the court, highest court in the land. The decisions that they make are binding on everybody in this country. The amount of reading and writing that goes into a court case at the Supreme Court is immense. All right, it is immense. And so unlike a trial court, justices are familiar with the cases before they even enter the courtroom. Prior to oral arguments, the court will receive a brief from each party, B-R-I-E-F. A brief is just legal reasoning, legal argument why the court should side with either the plaintiff or defendant, one of the litigants, or the respondent, the petitioner and the respondent. There's different names for those that go to the Supreme Court, the petitioner and the respondent. They can also receive briefs from outside sources who aren't formal litigants. They're known as friend of the court briefs or amicus curiae briefs, when we talked about those earlier. So that's an important vocab term too, amicus curiae, friend of the court. We know interest groups submit a lot of amicus curiae briefs. Now, for oral arguments, the Supreme Court of the United States, when they're hearing a case, they will only allow a half hour to address. Each side will have 30 minutes, where whoever's representing that case is going to stand in front of the 9 justices, and they have 30 minutes to make their case to the Supreme Court of the United States. But remember, the Supreme Court at this point has already got the previous court's decision. They've already got the briefs that are submitted. They've already been through amicus curiae briefs. So really, you got 30 minutes to just try and press or change minds at that moment. Once that's over, they go back to conference. All right. And in conference, it's here in conference that our justices will then take a vote. They'll go through and they'll give their opinion. The Chief Justice will call on the Senior Associate Justice, and then they'll move around based on seniority. The Chief Justice can ask each to take a formal vote if it's unclear from their discussion. And once a tentative vote is reached, an opinion can be written. Now, the opinion is the decision of the court. And this is right here. This is 3A, is the opinion. The opinion is the legal reasoning behind the court. It's the decision of the court. You guys know there's 9 justices. In order to make a decision requires 5 justices to make a decision. And when 5 justices make a decision, they have made and set their majority opinion. We have 3 types of opinions. I'm going to add these in here real quick while you guys are watching. We have 3 types of, gosh darn it, I'm sorry, of opinions. Number 1, we have the majority opinion. And this is by far the most important because it is the decision of the court. And it is the opinion that sets precedent, which means that all other lower courts have to follow. But we have 2 other types of opinions, right? We have what is called a concurring opinion, and we have what's called a dissenting opinion. We'll get through those here in a second. So an opinion is the legal decision of the court. Typically, the Chief Justice will either write the majority opinion or he will assign it to somebody, but gets to determine who he's going to assign it to write the majority opinion. I can't stress this enough. Number 2, once the decision's made, it's not final until the court releases their decision. And I didn't get to this yet, but I will. The Supreme Court doesn't typically release its decisions till the springtime to early summer. Right? That's when the Supreme Court will release. So they could hear a case in October and not release its decision until April. So there's plenty of time for revisions to be made. Justices are free to write their own opinions, join in the opinions of others. And so when we look at 3A, those opinions written to support a majority decision but are stressing a different constitutional or legal basis, those are called concurring opinions. Concurring opinions. Concurring opinions serve no precedent. They serve no precedent. But they are judges who are stressing, here is why I voted the way that I did, Here's why I made the decision that I made. All right. The other type, letter B, is called a dissenting opinion. Dissenting opinion are written by justices who were in the minority, justices who oppose the majority opinion. Again, serves as no precedent, and they are simply in the dissenting opinion stressing why they voted the way they did and why the majority may have made it, why the majority opinion could be wrong. Number 4, the vast. Let me come back up here real quick and I'm almost done, so hang tough for today. We'll break this into 2. I want to stress here with number 3, writing the opinion is so important because the opinion is the decision of the court, but the opinion is the precedent. Precedent. It's the precedent that serves all courts across this country. And so when the Supreme Court, and like I said, we have so many cases I can't wait to get to. But when the Supreme Court makes a decision on school prayer, how they write their majority opinion is so important because it's impacting every school across this country. When the Supreme Court makes a decision on search and seizure protections, it's important that they write their opinion clearly. They evolve their writing because it's going to impact all the people across this country. So much time is spent reading and writing and rewriting these opinions because it's now the law. It's public policy serving as precedent. All right, number 4, the vast majority of cases are settled on the principle of what's called stare decisis. Stare decisis. Stare decisis. It's a Latin term. It means to let the decision stand. We oftentimes think that when the Supreme Court decides to hear a case, they're going to make new groundbreaking policy. But to be honest with you, the vast majority of cases, the Supreme Court simply ruled that the previous court got it correct, that the circuit court or maybe a state Supreme Court got it correct. So when you say stare decisis, it means to let the previous decision stand, that the earlier decision, the decision by the previous court, is going to hold for the case that we have considered. And then 4A, all courts rely heavily on precedent. Precedent. The way similar cases were handled in the past, a means to guide decisions. When a Supreme Court makes a decision, that decision is binding on this country. But again, the Supreme Court has to have lower courts make sure that their decisions are being implemented. So when the Supreme Court makes a decision, they are instituting what's called precedent, right? They are setting a guideline for every court that is going to deal with an issue and it's going to come across this issue. Here's the guidelines for the decision. And so, using the 10 Commandments in the middle school, the Supreme Court has already made a decision on public schools, 10 Commandments, etc. And so when they're writing their opinion and laying down the framework for that opinion is setting precedent. If we have a lawsuit at a lower court, in that case would be a federal court, here is how you should make your decision. It's called precedent. Precedent can be overturned. It can be changed. You guys understand that. It can be chipped away, and we'll get to those things. But precedent's very important because it guides all of our courts across this country and how they should handle certain decisions that they make. And lower courts are expected to follow the precedents of higher courts. All right. The Supreme Court can overturn its own precedent, as it did Brown versus Board of Education when it overturned Plessy versus Ferguson. And why the court spends so much time? When precedent is not clear, the law is less firmly established, there's more leeway, judges become more political players with room to implement their own values and influence. Why it's really important when the Supreme Court makes a decision, that decision is written clearly so that all lower courts can apply that decision. The Supreme Court decides very few cases. In a typical year, the court issues fewer than 100. We talked about 80 formal written opinions. But something else the court can do, the court can reach what's called a per curiam opinion. A per curiam opinion. P-E-R-C-U-R-I-U-M. A per curiam opinion is Latin again, and it means a decision without an explanation. A decision without an explanation. There are times, guys, when the Supreme Court simply has to settle a dispute. And that dispute will never happen again. It is such a significant dispute between two parties that only deals with this particular issue in this particular time, and it serves no precedent. So if it's going to serve no precedent, why does the court need to write out an opinion? Well, they don't. So a per curiam opinion is done in conference. All right. I'll come back with an example for you that the court made a per curiam opinion in the fall, and I'm trying to think off the top of my head, but I'll come back with an example for you when we do our next one of these. But a per curiam opinion is a decision without an explanation. And it's when the Supreme Court is simply using its authority as the highest court in the land to settle a conflict. That conflict serves zero precedent. It will never happen again. It's unique to one situation or scenario. So they make a decision, they do it in conference, and they don't write an opinion. Once a decision is reached, copies of decisions are conveyed to the press. It's announced in open court. We'll start with letter E, implementing court decisions. We'll pick up here next time. This is a little too much for all of us, all of you guys. All right. Hopefully this turns out well. Hopefully I can upload this and get this to you, and hopefully you find some use for what I've just done. Take today, and you can go through your notes with it. Don't forget to check out the PowerPoint, and then we will convene back on Thursday. I will finish the notes probably tomorrow and see if I can't upload those tomorrow. So thank you guys for listening along for the better part of the last hour, and I'm going to try and get this uploaded to Google Classroom. See you later.